Well, good evening, welcome, and thank you for coming tonight. My name is Matthew Altus. I'm the founder and owner of AltLaw, who are your hosts tonight. We are a litigation support company operating out of London, and we've come over here to deliver a seminar on cross-border data privacy and the EU. We've got a great lineup for you tonight and some very knowledgeable speakers. But first, if I could just introduce my company to you. Founded in 2004, AltLaw operates out of London, England. We cover the services from the entire range of the EDRM, from forensic data collection and investigation, processing, online hosted review, managed review, technology assisted review, and all the way through to disclosure and production. The particular services we thought were pertinent to the discussion tonight were the global forensic data collection, which being near London Heathrow and that being a major hub for international travel, we pretty much have boots on the ground anywhere in the world within 48 hours with mobile labs to collect data. Where the data can't be moved, we have a mobile solution which is powered by EDT, and you'll hear a bit more from Joe about that later on, where we're able to collect that data, process it, and cull it, and get it ready for hosting or returning review at a later stage, or managed review by us, should that be what is needed. Also, you'll find often in Europe, a lot of the data that you need is still on paper. So we're able to dispatch scanning teams, mobile scanning teams, to capture that data and have it ready for coding for you then. The other service that we offer, and pretty often for US attorneys, we often get calls where you need to submit your depositions and bundles in UK courts in paper form. So you're able to transfer that data to us by FTP, and we'll have that printed for you, delivered to your hotel room, office, court, wherever you need it, as and when you need it. And that service is available 24/7. So thank you for that. That's about all from me. I'm going to introduce you to Ignatius, who is going to be a moderator for tonight's seminar. Thank you.
Thank you, Matthew. And I also want to welcome Adam Page, who is also with AltLaw. And Adam and I go way back to 2007, when we both were working at Clifford Chance. And we were on a very large matter that took me on the other side of the Atlantic. And without Adam's help and advice dealing with the data privacy issues on that case, which probably a little earlier than we were dealing, before many people were dealing with those issues. He was a great asset on that case and a good friend since, so I'm glad that you guys are in town. So we're going to try to keep this conversational. Please raise your hand. If you came here with questions that you wanted answered, please ask them, even if it's kind of getting us off topic. I think this is an issue, an area that is challenging to all of us, as far as the different ways in which this comes up and how to deal with it. And there's, as we're going to talk about, there just are very differing views of between the U.S. and the EU on data privacy, and more of the cases that we deal with are cross-border cases where you have companies where there's it's almost infrequent where you just get data from one country, one office, but more often than not, we're having companies where there's people in the EU, in Asia, in other offices. You have to collect the data and think about what you need to do, how you can do it. You respect the client's needs and the laws in the country that they work, but at the same time deal with the U.S. court system. So that's what we're here to talk about. I'm going to introduce our panelists, and then we're going to kind of go through just generally a rough outline of topics we're going to want to hit. But as I said, please raise your hand. I hope that the panelists, kind of all chime in on different points and questions. But without further ado, Mike Taylor. Mike is the CEO of iLit Limited. He basically does e-discovery consulting, in particular on cross-border matters. Deals with data privacy issues quite a bit, and he is not based in the U.S., but based in the UK and Europe, dealing with these issues. We have Brian Corbin. Brian, I've known for several years. Brian is currently Vice President at JP Morgan Chase and the Discovery Program Manager. And a big part of what he does is manage cross-border discovery, and he deals with a lot of information governance issues as well at JP Morgan. Next to Brian is Joe Sherman. Joe, as Matthew indicated, is the founder and CEO of EDT, which will tell us a little bit more about that. And Patrick Burke. Patrick is Senior Counsel at Seyfarth Shaw, and also is the Executive Director of the Cardozo Data Law Initiative. And he's, as I do, teaches at Law School at Cardozo, has really done a great job developing that program and thinking about these sort of issues and raising these sort of issues for law students, which I think is something that doesn't happen in a lot of law schools.
We have a couple of those law students here, so feel free to introduce yourself to, well, an ex-law student and a law student.
We expect good questions. So Mike, why don't you maybe get us started? We talked about, I just mentioned about the clash of the U.S. and EU and how we have different laws, different data privacy laws. Maybe just give a little background to us.
I'm just going to swap over so that we can see what's going on. I think this is a really important part of everything that we're talking about today is the clash of cultures between the US and Europe. And the UK, luckily for me, kind of sits halfway in between. I think we have a common law background, but we're also subject to much the same, or many of the same laws as our French and German, Italian and European generally counterparts, which I think allows us to have not a unique understanding, but a better understanding of both the European, continental European perspective and also the US perspective. So you guys have very broad discovery from the UK perspective. We do think that it's a pretty wide-ranging discovery process that you have. I should point out that I am not a US litigator. You guys will almost certainly know all of the laws and all of the rules far better than I do. So don't try and pick my brains. I won't win that argument. In the UK, we have a common law background, which you borrowed from us, and
wrecked.
But we are checked by reasonableness. Our overriding objective of the civil procedure rules has just been changed. So it's now written into the rules that not only are we, our lawyers in the legal community, obliged to deal with things justly, but also it is now written in the rules proportionately, at a proportionate cost. So there is no getting away from this. The whole point of lots of reforms really over the last 20 years has been to make litigation and access to justice available for all. And just because you've got a whole lot of money doesn't mean to say that you're going to win every argument. And that's now written into the rules. In the EU, they don't really do discovery. They're not really interested. They have a civil law background. It's mostly judge-led, so judges will sit there and say, I want to see these documents from you, and I want to see these documents from you. And that difference in culture is really important because, I'm going to go to the next one, there we go. Oh, hang on, that's a different one. I'll come on to why it's, I'll touch on it now, but it just means that when Americans ask Europeans for something, and you guys think that it's totally reasonable and normal, the Europeans think that it's an absolute outrage and how dare they. And that's the base position, it really is. And I think the emphasis is going to have to be on you guys to adapt to, you're asking them for something. So when you're asking somebody else for something, you have to do it in a way which is, you'll still hopefully end up getting what you want, but you need to do it in a way which is respectful of what they understand and what they're expecting. When you couple that, probably, if you can change it, when you couple that with our different privacy cultures as well, and I'm talking about data privacy here, my understanding, and again, you'll probably tell me I'm wrong, but there is no overarching legislation which protects citizens from the use of personal data by governments and corporations. State by state variations.
That's about right.
Is that right?
That's about right.
California's a bit tighter, isn't it?
Well, Massachusetts, yeah, but it's very sectorized. It's not broad.
There's no data privacy.
Right.
There you go. There's no. There we go. I was pretty much right. Whereas in the EU, it is literally a fundamental human right. It is Article 8 of the. I've got it written down somewhere because I never forget it. It's Article 8 of the European Convention on Human Rights. So it is there. It is not messing around. And unusually for European law, it's something that the Europeans, continental Europeans, take really seriously. And in the UK, we're less bothered. Normally it's the other way around, where we obey the rules and they don't bother, but in this instance, it's true. In this instance, they are really keen on data privacy and they don't mess around. The EDRM there has a really good resource which is written mostly by DLA partners from the various jurisdictions about what the position is within each of the European states and also other worldwide.
Baker and McKenzie is a very good guidebook too.
But there we go. So if you prefer the state's choice, DLA or
Just, I think a lot of people know this, but one thing I always find fascinating, does everyone know why we have this, why the EU has data privacy regulations? Some nods, but I mean, I think that
One of my students.
one of Patrick's students, why do they have these data privacy laws? What's the why?
I don't know, the Nazis, the fascists, the Cold War.
Yeah, and then I think I never thought of that back, when I first started to deal with these issues, but it helps understand also why I think European countries are so
There were secret
strong
services,
about
the
these.
KGB, the Stasi, and there used to be that any information they collected, could put you in jail. And so, if you look at what they consider private, personal, especially sensitive information, it's things like gender preference, or religion, or labor union status, or there were other things. Those are all things that were on the Nazi hit list. And you look at our, what privacy laws we have, their financial data, their health data, that's about it. And because we're not worried about, it's like, oh, really, we're sensitive to things like maybe your sexual preferences and stuff like that, but they're not considered something you're going to get rounded up for. So, we, in this business, we're all about, the American lawyers in Discovery are all about the quest for justice. Like, it's the quest for justice. That's why we're here. Yes, it has to be proportionate, but it's a quest for justice. And there, it's privacy is a fundamental human right. And, the quest for justice is way lower than that. And for us, the quest for justice is the privacy right. And that's why we talk past each other, because we each think we're right now.
I think, the other thing I find interesting is, what Patrick just said, you look at every European, you look across the different European countries, and you look at France, at Germany, and those are the countries where really that they even have the strongest data privacy laws, and it's for that reason, they are the ones that are more sensitive to what happened in World War II.
But I think this is brilliant. This is not just World War II. You've got to remember the Berlin Wall came down in the 1990s. 25 years ago, East Germany was collecting everything, absolutely everything, sharing it around. Bang. So that's where it comes from. Luckily, we never really suffered from that. So that's probably why in the UK we're less bothered.
Right.
In Australia, we don't care at all.
No. We're just
Privacy.
the Second World War happened.
Right? Like, throw on a t-shirt.
Yeah. Please.
You're going to get sunburned.
So there's going to be so at the moment, the European privacy laws have been implemented through a directive. But I don't know how interested anybody. The European directives are made by the European Commission, and individual governments have to then have a time period in which to implement them in their domestic law. So which is why we have lots and lots of different interpretations of the same directive, and why it's complicated. It's going to change into a regulation early next year. Now, a regulation is just a set piece of law that is Europe-wide. There'll be no opportunity for domestic governments to interpret it and put it on their own statute books. It is a Europe-wide piece of legislation, and that's going to cause massive issues for everyone because the way in which it's interpreted in the courts is going to be different, and it's got these huge potential fines for breach. Talking about 2% of worldwide turnover of companies that breach the new regulation, which is massive. And we'll come on to it later on. But when you're balancing, I think you all probably know, you wouldn't be here otherwise. You all probably know you're between a rock and a hard place if you're trying to get data out of Europe, US litigation. If you're going to breach a law somewhere along the line. And if you're balancing which one to breach, suddenly FRCP looks like the one to breach because nobody wants to get fined 2%. So
Is there a view that will happen, or?
yeah. The draft regulation says that. In fact, there's talk in some of the press and massive press coverage, as you can imagine. Constantly front page of the Times. There's talk that it might actually be 5% of turnover. So
Politics is all moving in the direction of more privacy regulation and stronger and outrage over corporations. And the Sedona conference, which is kind of our lobbyists there, who have been very engaged with, is still engaged with the European privacy officials, have been trying to work out a meeting of the minds, and they've been doing this over the years, and trying to explain what our litigation process is, and why we do it this way, and possible compromises. And they were kind of making headway until Snowden came around, and it all just backslid, and we're miles apart now. So if this was 5 years ago, we'd be talking about how we thought we might be able to bridge some gaps and work out, if it's for litigation, then there'll be a certain set of rules, it'll be streamlined, there'll still be protection, but it's looking further and further away.
How close are we to
Like, how close it
to being implemented?
To it.
The new law.
Yeah, I think you had it right. I think they're talking about it next year. I don't know that it's.
well, they talked about it last year, so
Yeah.
they keep on putting it back. But I think it's
Well, when did the new
January.
president take over? Is that this year? You don't know. There's a new president.
I couldn't tell you the name of the
He's
new
your
president.
president.
I know,
so
I
she's your
couldn't tell you.
president.
No idea.
By then you're gonna secede.
Who's it? Barossa. Portuguese guy. No?
Anyway, they were hoping to do it before the regime changed, because otherwise they might have to sort of start over again a little bit. And so it hasn't happened yet. Yeah, we're all.
2016.
That's a new plan. Well, also has been 2014, 2015.
That was a plan. Yeah.
Does anybody know who the European president is?
Latvia,
But you don't know the guy's name? No.
well, actually, perhaps I just can't pronounce it.
No, it's private.
Yeah.
I mean, you can't post that.
Individuals' names.
So, I think we all got a good understanding.
Let's get some more wine.
So we've got really, I mean, we're miles apart. The US and Europe are miles apart, and luckily the UK sits in the middle. There is a Hague Convention, which should, in theory, help us help you get data out of Europe. It's part of your law, it's part of our law, it's all signed up to, and it is the real thing. Just to read one out really on this one, I'm not going to go into massive detail, but it involves asking one court asking another court to assist in getting data out of the jurisdiction of the other court. It's long and complicated, and US courts view it as supplemental to the FRCP rather than an alternative method. So you've got to go through the usual discovery process. If all else fails, go to the Hague Convention and then get your letter of request out there. I think it's really important that, and this is another key difference, the letter of request under the Hague Convention has got to be really specific about what we want. If it's not, if it's a broad sort of, we want everything relating to whatever, over this long period of time from all of your employees, they're just going to say go and go back again. And it takes a hell of a long time, so 6 to 9 months. So it really is laborious. It's going to totally throw your court timetable out of everything. It's really not the place you want to be. But it does provide a framework, and we'll come on to some other irritating things
I
about
just had a
it.
comment about that.
Yeah.
Oh, if you have more irritating.
Yeah, I've got loads of irritating stuff. Loads of irritating stuff about the Hague Convention. So it's, as I said, it's unlikely to work. The French, the Germans, and the Spanish have explicitly banned the use of the convention for discovery requests. So there you go. So you've got US courts saying, we really don't want you to do this, the FRCP is fine, and you've got these helpful European friends of ours saying, no, you can't do it anyway. So it's a nightmare. It takes a long time, court timetable's gone, and the US, were you going to say something else about how irritating it is?
I actually was going to give a practical tip, which was going off the fact that you were saying it should be very specific, and it turns out if you do it in England, you can do better. So if you're looking to get data out of England, England's not really hard privacy-wise anyway, but it all goes, when you send a letter of derogatory, I guess when the judge sends that, it goes to this one person in England who's the senior master. So it used to be senior master Stephen Whitaker, but now it's somebody else. He retired last year. And so he would talk about it, and he would say, yeah, there's a certain basket I have where those go in, and I go through them, and they're usually from the States, and if they're very specific, as in pretty much almost asking for exact documents, he goes, I routinely approve immediately. If it's general kind of U.S. discovery, like all communications related to X, Y, and Z, he routinely disapproves them. But when asked about privacy, I said, well, do you think? What about privacy issues? Do you put some kind of limitation on that? And he said that when it comes in a Hague Convention request, it's under a treaty. So Hague Convention is a treaty that all these countries sign, because a treaty trumps a European directive. So if you ask for it, from his point of view, the privacy laws don't matter. So if you're going for something in England, you're worried about privacy, it may actually be a useful approach to avoid the privacy issues. You just request specific documents through the Hague Convention. I don't know if the new senior master has
It's
a
a long
different view,
process though,
but.
isn't it? Well, it depends on the master that's
You know,
making the.
he claims to turn them around within a few weeks.
But he's
It's in order.
He's turning them around. So he turns around an order. There you go.
He orders
then,
it, yeah.
then you've just got to start.
Yeah.
But before you've even got there, you've got everything going on from over here, taking.
That's
months
true.
to another.
It's a problem, but you know what? Our alternative method is not that efficient either.
Yeah.
You know, and it costs a lot.
There we go. This is probably what we need to say. So it seems to me to be that you need to, well, firstly, just try not to do it at all. Is the data in the US or somewhere else other than Europe? If you could, that's kind of your first point of call. Try your hardest to find it somewhere else. And if it exists somewhere else, get it from somewhere else, because it really is tedious getting it out of Europe. But so you then have to go through Europe probably if you want a friendly court.
So when you say getting it out, are you referring to data that's already in Europe for moving, or what about data that's passing through Europe? Say from the United States through UK to Africa or Asia?
Well, if it's coming from the United States, just get it out of the United States. So take the data straight from the US.
Right, but if the data, the communication line is through Europe, right? Like we have a technical guy, but our data runs through the UK before it goes to other places. Would that make it subject to?
If it's sitting in Africa on a different server, physically it is a file in Africa. Take it from Africa.
Right.
Depending on the particular state's data privacy laws, which I'm not up to date with in Africa, I have to say.
Well, I mean, maybe what you're saying too is that if you have data that's available in the US and maybe in Europe as well, if it's available in the US, you may be able to avoid having to pull it from,
Right.
at least the US courts will say get it out of the US.
I've heard of people taking U.S. data collected in the U.S. and even sending them to say England. England's a very common location to do this kind of work because they're still within the privacy blanket of Europe, and they're user friendly, and you got great vendors, so you can do that kind of stuff. But they'll actually just match up what they already have in the U.S. with the European data, and then they just take the delta, what's left over, and you go, okay, now we have a smaller amount. Now let's just work on that. Like getting volumes down. Just literally, you do them.
Yeah. That's a good idea.
That's a business idea.
That is.
Brian, do you deal with that? As far
Yeah,
as-
a little bit. Yeah, sorry, I think you might have disclaimer. I don't speak on behalf of JP Morgan Chase, et cetera. I mean, simple example is if it's email conversations between custodians in the U.S. and any other country. That's the first step we're going to take. Just get anything that's possible in the States first, and then, like you said, we take the delta. It's invariably going to be a much smaller population. As far as data bouncing off of places, that's a bit more difficult. I think we see a lot more of that in APAC, where a lot of folks have email servers in Singapore, for example, so it'll hit Singapore before it hits 10 other countries. Operationally, I think that'd be a lot trickier of a process to try to put some sort of a net into your discovery process to get that stuff. And Singapore is a bad place to try to do that anyway. This conversation is about the EU, though, so we'll get back.
But it's also, I mean, a lot of it goes to whose data is it, like wherever it's bouncing. This is not, but if it's a particular employee and that employee is in Germany, you really should go to that employee and ask for consent. And you have a paper in there about some of my experiences with collecting in Germany. But yeah, if it's a German employee, now I've had German employees where they're now stationed in China, or it gets all mixed up. But I think German is, or wherever they may happen to be sitting that day, it's within their purview.
And then the tricky part, and I'm sure we'll cover this, is that consent doesn't necessarily mean anything if it's from your employer.
Well, why don't you make that
That's
point?
just what I was going to say.
That's pretty much
Make that point.
But,
We get consents, and you probably do too. I mean, you want to. It's all what we call belts and suspenders. It's what can you do, and so that was it. Belts and braces.
Belts and braces.
That's an interesting
Yeah.
analogy.
So, you do it even though you realize they could revoke it, or a data protection official could say, oh, that was coerced because they had to do it because you're an employee. But I generally operate on you get the consent, you make the consent. I have a certain one for Germany, I have a certain one for, you want it in their language, you want it, and you want it to relate to the data privacy laws in their country, and say, really explain what you're going to use the data for, what the case is about, and this implicates your law in this country, and we're very careful about that law, so we want you to know. I think it's the most good faith kind of thing you can show if you care about it.
And it goes to reasonability and proportionality as well, as the rules shift that way, at least for the UK, we're in better shape.
I was going to say that's excellent actually, because you'll find that if you follow that procedure, you never have that many problems, because the idea is to show them that you are going to utilize the data exactly for the reason that you're collecting it for. And if you had to deviate or the investigations go somewhere else, you just won't use that data for that without getting further consent from them. And I think that's the idea. I think sometimes the difficulty or the problem is where a request is made and it's very vague. People are not specific, and they then don't understand why their request is being rejected. The only other thing I wanted to add as well is that I hear when we talk about where the European privacy laws come from, how it started, etc. But we need to bear in mind, compared to the US, Europeans take their privacy very seriously. And the ramifications, if anybody has that data and it goes astray and something happens, those ramifications can be quite seriously. So it's not just because of the war before, but now with today's generation, etc., privacy is taken extremely seriously. And the organizations that are collecting this data have to give an undertaking that their data will be used for specifically what it's being collected for and nothing else. And that's why sometimes if you want to get data from the internet, even though Yahoo or AOL, none of them will have any problems giving it to you, they still need to get a court order so that they cover themselves. They wouldn't just give you the data because of those privacy reasons.
Absolutely, right to be forgotten now, which is really fun as well. So that's probably for a different day.
But on top of that too, to Ing's point, does it really matter where you review the data? In that particular case, say, Patrick, if we're reviewing and say London, probably not, but maybe in Germany, maybe. Does it really matter where we review the data?
I think.
No.
Me, you want?
Go.
I think a lot of it relates. I'm speaking like as a law firm lawyer who has to work through, and sometimes we work in-house lawyers, and they work. They're here and they're trying to understand how to work over there. But if you like in Germany, so I give the example in my paper. So if you go to Germany and you want to collect data, you got to run through the Works Council, right? So aside from the consent, your IT people should really be working with the Works Council, and they should really set up a procedure with the Works Council. And because if you just come in and you say, hey, Works Council, I got to collect this thing in 2 weeks, they'll be like, no, you don't. You go on our agenda, I think we have space next January to discuss this. It's just not a priority for them. So it's very important that if you're in that kind of situation, to plan ahead. But if you are making an appeal to them to, hey, let us do this, we have a Senate investigation, we have this going on, there's a bunch of things that you can say that will make the medicine go down easier. And one of them is we're going to do a very selective search we're going to use keywords, and we're only going to pull the things that are responsive to these keywords, or anything you can do. If you can say, we're going to collect the data and keep it in the company, or at least keep it in Germany, they will feel much more safe. If you're gonna review it in Germany, even happier. It's just like whatever you can do to slather it on, because they can just say no, you know, and they can. And if you go around them and you just get consents from employees, you know, usually that works. But you can get, fallout from it too, and then you won't be able to collect anything for a long time.
I have a question, Patrick, about, in the scenario about Germany overall. Like, number one, what constitutes a German employee versus, like, what is subject to the Works Council, etc.? Is it someone, if someone is brought over from America for 2 years to work on a project in Germany, is it data that's generated specifically in Germany? Where does the jurisdiction?
I haven't heard them say which of those they choose. I think it definitely applies to German citizens. Although I've seen people argue that if the German citizen is now living in the United States for 20 years, it doesn't matter. So I don't know
It
the
doesn't
answer to
matter
that.
if the job is still considered.
No, it doesn't matter. No, companies take the position that you've been here a while, I'm not going to treat you like a German. But I actually don't know the answer.
I was just going to add, it also
we've debated that. I've heard people debate that, but I don't know the answer.
It also depends on if the data is residing in Germany, because I do quite a lot of work with that, and we have people from America, the UK, who are working in Germany, and it still applies to that data there as well, even though they're not German citizens.
Do you work in a company that?
I work for Deutsche Bank.
So am I right about
Yes,
working
you
for
are.
the Works Council?
Yes, you are indeed, yes.
Yeah. Okay. Have you negotiated something with the Works Council?
Many. Yeah. They're always happy if the data is staying in Germany, first and foremost.
Right.
If you're ready to work with the data in Germany, you won't have problems. They worry when you take the data out of Germany, because they do not believe that you will maintain their rules and procedures with handling that data once it leaves the jurisdiction.
What if you're moving to France or the EU, or to UK?
Well, we in the UK,
Yeah.
we still do everything in Germany.
You still, yeah.
We would say.
So I think probably from a...
Legally, it should be
Legally,
fine.
it should be fine to do the
Yeah.
review in England or in France or
Yeah.
anywhere else. But I think actually
Yeah.
from a politics, going out with kid
Yeah.
gloves, do it in the jurisdiction.
As a matter of fact, they're actually more comfortable with moving it within Europe rather than it coming all the way across the water. So.
No, nobody likes any data to take Americans.
Now, is that a German, Patrick? So let's say you're in France or the Netherlands, we have a Dutch
I
lawyer
think
here.
it would work, but I wonder whether it works for your discovery procedure, because if you need the data for your discovery procedure here, then I assume that you need to have it here.
Yeah, I think we're doing a shorthand here.
Right.
It's an insider shorthand,
Yeah.
which is we'll review it in Germany,
Yeah.
we'll cull it down in Germany,
Yeah.
and then we'll have a smaller amount.
Small.
But we're taking that to America.
But we'll
Right.
redact that before it leaves
Yeah.
Germany.
So
You
it's,
might redact some of the sensitive personal information.
so it's almost like doing the first level reviews and also doing the privilege, etc. before
Yeah.
it's then,
Get
taken
rid
out.
of Priv, get rid
Yeah.
of
Right.
all the
All
junk.
of
Do you redact, I shouldn't put you on the spot. But do companies generally, when they deliver it over to the States, do they do a redaction
Yes,
of
they do,
all
actually.
names?
Names. The way we see privacy, I should say, is that if you have a name, just the name of an individual, there's nothing private about that, because 100 people could have that same name. It's a combination of the name, i.e., let's say date of birth, social security number, etc. So it's a combination of that data that makes it private. So when you're looking at the document, if there was just the name and nothing else, it's not really a big deal. But when you have enough data that anybody that could read it could identify who the individual is, that's when the issue is. So we tend to redact quite a bit. Even audio now we will redact. So we'll actually send you an audio file and you'll hear a lot of bleeps. because that's the data that covers individual privacy.
Deutsche Bank employees swear a lot.
Funny enough, it's actually...
Hours and hours.
Yeah.
I remember a debate with a German data protection official, and he said, well, you know, what if Volkswagen had a defect in a car and it killed 200 people in the United States? And so it was a class action lawsuit, and the defect was something where the only information you can get about it is from like the safety lab in Hamburg or wherever it is. And so the key evidence is their reports, and like that, you know, some key person in that lab said, I think these are unsafe, right? And so I said, you know, would we get that document? And he said no, because A, you wouldn't get it with the guy's name, and B, you wouldn't get it anyway because he expressed an opinion, right? And I'm like, okay, so that's totally quest of justice versus fundamental human rights. So they said, like, well, what if it was the president of the company? He goes, well, of course, it's the president of the company. They represent the company. And I was like, all right, how about the senior vice president of the company? It's like, yeah, probably. And I'm like, well, where do you draw the line? And they go, like, you know, not at the lab guy. You know?
Because they look at it from a responsibility point of view. Also, to bear in mind is that when you're making the request, depending on the case, it's quite subjective. So it wouldn't be as general as that. There would be instances, depending on what happened and what you're looking to do, that they may actually either give you that or will work with you in order to provide you with the information that you need.
Well, the other side is that, let's say, if you don't produce, the judge in the United States says, okay, $20 billion award, right? That tends to grease the wheels on the other side. So other people start violating privacy laws at that point.
Right.
So
It turns into a math problem, or a risk
it
balance,
is,
whatever you
it's
want.
like a risk.
Right, which changes once you get 5% of turnover.
Well, I was going to say,
Now-
That's right.
It is. I think, I mean, you look at,
Great.
I mean, if that actually does happen, I mean, it is interesting to think what that would mean, because then, I mean, right now, and we're not really going to get into this today because it would be a whole other hour, but you know, the U.S. laws, as many of you in the room know, don't really care about what we're talking about. You know, the judges, as I've spoken to many, will, you know, look at I always get it mispronounced, Aeropostale, and cases since, and you know, we'll find that you need to bring the data into the U.S. But I do think, I mean, that's when all of a sudden there is a penalty.
The losing side of that argument where they say, well, guess what? I'm not going to give it to you because the penalties in Europe are far greater than anything you're
Right.
Are they going to up their game to make the penalties harsher so that they win the document?
Be a big fight.
Penalty war.
Yeah. But I mean, the thing is, look, we pulled. I got like 10 people's data today from their laptops. It's crazy,
Americans?
right? Americans, yeah, Texans. Super Americans. But so these, you know, so the idea, this whole thing, like, oh, let's take Joe's software, put it in the, you know, have AltLaw come in, put that in there, process it, you know, do the privacy sweeps, do everything in there, to the point where you only have what's relevant for the case, and it's not like what I have, which is I have everyone's pictures and I have everyone's everything, you know, and then only then you know then they can like produce that out, you know, that's a big improvement. It makes a lot of sense, you know. I think that you know, to the extent they're waving a big club at you, is probably the only thing that would work, you know, to get us to really, you know, to go to the trouble of sending a vendor, you know, to go in-house there, set up an instance of EDT, run the thing, and all that kind of, you know, we wouldn't bother about it.
So speaking of that historical context that we did before, I mean, something like getting that from you know, a custodian in Texas, do you think it's done because there's a greater value placed upon attorney-client privilege and trust? Does that not exist in Europe to the point where people aren't eager to even give it to their own counsel? Or
Well, they give it to their own counsel, they just don't want to give it to Americans.
even if their counsel is an
That's all.
It's
American
a cultural
firm?
thing.
It's a cultural
And
thing.
again, as an owner of a data privacy process, a huge disadvantage that I walk into the room with every single phone call I get on is my American accent. It doesn't matter what's going on behind the scenes. I have a teammate who's British. I put her on every call first, grease the wheels, because she's going to get 10 times as far as I ever could. Now I need somebody from Germany on my team.
I'm really glad that she said that, because it's very difficult to come to America and say, yeah, it's difficult because the Europeans just don't like dealing with America.
Right.
Practical
Privacy instead of privacy.
It's true, and I can't necessarily blame them. Because again, as an American, I have no reasonable expectation of privacy to any of this stuff.
Yeah,
It's not something that we as lawyers are educated on, typically until now, which is great. It's not a part of our culture. So there's a mistrust that's warranted.
And I was going to add that it's actually quite unfortunate because when you look at cyber attacks and things going on now, one would think that privacy would be something of importance with all the money people are losing and organizations, etc. I mean, I always find it very astounding, when I go to places, and I give you a good example. I recently wasn't feeling too well, and I went to a CVS supermarket to get my prescription. So I'm standing in the line, and there were quite a few people, must have been about 10 people behind me. And she just called out my name, and she said to me, "What's your social security number?" And I said to her, "I'm not telling you." She said, "Well, if you don't tell me, you won't get your medication." I said, "Where I come from, they probably would have asked me ID or at least be a bit discreet."
Right.
I said, "If I tell you, at least," and I turned to the others, I said, "No disrespect, but at least among you, one of you is probably an identity theft person."
Right.
And because I do this as a living, I see so many cases as a forensics investigator, and I see how very easy it is. So I do believe that at some point in the U.S., privacy is going to be taken a bit more seriously.
Well, I'll also say, flip side, a few years ago, I worked at Guidance Software, so we made in-case software, which is this software that searches through all your stuff and finds it and pulls it back, so potentially intrusive. But it's also used for malware, so they go out and they do scans to find viruses and stuff, and that's how they find out something's going on, because they literally go through and search through and look for viruses. So a labor union was having a dispute with one of the big, I forget if it was Raytheon, it was one of the big defense contractors in the States. They have a huge program in Germany. And they were having like a labor dispute, and they found out that they used Encase. And then they went to the Encase website and they found out all the ways it could violate your privacy. And then they went to like the head investigative journalist for Der Spiegel, which is like the big magazine, and he did like a front page story on how this company was using, they called it Schnuffel software, it's like spy software. And so like the president of that division in Germany is like calling up right away, like rip that stuff out. And so we're doing this conference call, and you got the people running IT saying, we can't do that because otherwise we're just going to get destroyed. We're not searching for any stuff. It's just we're searching for malware. We're not searching for that. And and the guy was like, it's coming out now. And guess what? It didn't come out because it really couldn't. But it's at that point. Where the capability to do it.
Yeah, I mean, there's still some companies, especially in Europe, who wouldn't allow enterprise tools in the environment because of that mistrust as to how people would use it. And I think sometimes people forget that we call them anti-forensic individuals because they're using the exact same tools that forensic people are using to solve these cases. So it also makes it very, very difficult. So, but when you have privacy all over the place, I mean, I always say to myself that if I was on the other side, thank God I'm not, I would be a very rich person in America because I'll have at least 100 identities and have a big mansion somewhere. Because it's very easy to accomplish that, in my opinion.
What happens in that instance, though? Let's just say the data somehow is either leaked out or moved. If you're at JP Morgan, you've somehow gotten the data, now it's in the US. What happens in that case then? Because you could have, the same with data privacy or cyber leak or something like that. Data's out there, it's broadcast, now it's in the US. What happens in that case? Is it discoverable? Can you go after that data if it resides in the US?
Missing.
Well, if the data is
had to get to US.
If the data, say the end case situation, and you pull the data out, and out of in Europe, and somehow it ends up in the U.S., or maybe not in that case, somehow it ends up in the U.S. Is it discoverable then? And maybe it's you've had information that
it is an issue that it's discoverable if you bring to, well, if you take something, it's actually an issue where anytime you use an enterprise tool to collect and you keep the files of what you collected, you now have to you should really get rid of those as soon as you don't need them, because you now have to run searches on that data for everything else you do in the whole wide world.
I think it is discoverable, but the people who inadvertently, the data controller who inadvertently let it go from Europe would get a fine.
Sure.
But I know companies, I won't name them, but they keep their European data on servers in the US. Like the server is in the US, because they don't want to mess with it. It's still, violating the rules, but they don't have any, outraged German people around who are going to call on it.
Yeah.
Yeah, I have a question. I mean, is it the people that are upset about this, is this really like a grassroots thing? Or how much of this is just politics and sour grapes over Snowden and Google? I mean, is this...
It's not sour grapes over Snowden and Google.
Yeah.
They kind of came post the law. It's a bit of politics. It's a bit of making sure that things don't happen again. But it is something that your average, everyday Joe Schmo on the street takes quite seriously.
Absolutely, and we also expect the government to protect our privacy. I'll give you a good example. I mean, if, for example, I had registered to go to university here or something, and there was a leak and my data, went out, having signed a documentation, which normally when you look at, even on the internet, when you look at terms and conditions, which most people unfortunately don't read, it tells you exactly what they're going to use that data for. And usually it doesn't tell you that, it specifically tell you that your data will not be shared, with the exception of Facebook. Now, if I then turn around and I start getting marketing material, and I feel that my data is being shared, I could sue them, because I haven't given them permission to do that. That's why in the UK, if for instance you went to my university, you wanted to get my transcript, you would have to ask me for permission. And they would contact me to get permission. If you don't, before they release that data, otherwise it wouldn't. Because if it's released and I find out, I have a case against them, and they have to protect themselves from that.
I don't know if this happens in the US, but if you go to a website and it uses cookies, do you have any sort of notification about that? Every website now in the UK, you go along and says, we collect cookies, we collect your personal data.
Yeah, you click at the very beginning.
There you go, yeah, fine, whatever.
Yeah.
Yeah.
You got all the notification in the world if you read them.
Yeah.
We don't have the same notices though that the UK has. That you have to put that. The US doesn't have that.
No, they don't. They don't have that. They do because became law in England a few years ago. So what would happen is every website has to tell you specifically that a cookie is going to be left on your computer. You need to click yes if you want that to happen, and they're quite tricky because they'll tell you if you don't, you won't get the full experience of the website. So it's up to you whether you tick it or not. But at least you've read it and the conditions, and it's telling you specifically that this and this is what we're going to do. If you don't sign it, they can't do anything. They can't even leave the cookie on your computer because the cookie, most people believe that it's there so that whenever you go back to the site, it helps you to access the site quickly. But it's not just that. They're actually scanning your system. That's why when you look at the marketing material, they always send you marketing material on Google that they feel may help you buy something that you may be interested in. That's because of the cookies on your machines. In the US, you don't have that. The only option you have really is to go in the terms and conditions where it's stated there, and you either have a choice whether you want to sign up or go on that website or not, but there's no control.
I think it's an interesting way. I think because of our Congress and government, it's unlikely there would be data privacy, that global data privacy law anytime soon. But I mean, I do think, just with the technology and the amount of data that is being collected about us, it's just something for us to think about. I mean, I think in a lot of ways, I think today versus 5 years ago, more people, you can better understand the EU way of thinking as far as trying to protect some of this data. You know, and even, I mean, Patrick was saying collecting the Texas laptops, you know, and now, I mean, every case we're imaging iPhones, and
Yeah.
usually they're personal iPhones that are used also for work purposes. And, you know, I don't want to see what's on those iPhones and the pictures people are taking. I mean, usually you don't have to go through the pictures, but you're getting all that data, and you know, it's.
Yeah, I wonder, like, maybe Joe, you can say, like, what, you know, what do you accomplish if you actually apply technology to it in Germany or whatever? Like, what do you?
Sure. I think one of the observations I'd make about this whole domain is the fact that the debate is all about moving data out of the EU. How do we get the data out? And that's what everyone is challenged with, and it appears that it's going to get worse with the penalty regime that is imminent. I'd like to suggest that there's a different approach, or you know, the opportunity to think differently about it. Instead of labouring over all of these confusing aspects of the problem in terms of moving the data out, why not keep the data in situ, take the tools to the data, and do the project on site? And I guess, you know, this has been something that we've been working on with, we're very fortunate to be working with AltLaw in the EU on a number of investigations that involve exactly that scenario. You know, we couldn't get the data out of the jurisdiction, and so we were able to condense a very sort of powerful solution that has processing, analysis, review, production on a laptop that, you know, is pretty powerful, can handle, you know, millions of documents, take it to the site and give the complete functionality. So it's not just collection for delivery back to the US, but do it on site. Because often there are people on site that actually know a lot about the facts. They're the ones you want to have doing the first level review in many cases, determining what needs to be redacted. You might want the Works Councils involved in that exercise. And this model is a really practical way, I'd suggest, to get around the legal quagmire that none of the experts in this room, you know, are you know, if we can't work it out, then, you know, what hope has you know, the average litigant got in this space? So I guess I'm excited about practical solutions, and it's really encouraging to see, you know, what AltLaw are doing in this space with our platform, and you know, I'm sure there are other platforms that can do this as well. But that's
Definitely for investigations. If you can do
yeah, well,
internal analysis.
internal investigations, and it's not just data protection. Data protection and privacy is obviously important, but there's often a situation where you have sensitive commercial matters that require a very light touch, or a very, you know, a very confidential kind of sensitive approach. And in circumstances like that, you don't want to be wheeling in a massive server and the fraud squad in terms of the forensic guys. You know, you want to keep it really under the radar. So I just think, you know, I find this whole space very exciting because, you know, there are solutions.
I'm just aware of the time, because I think we've not got very much longer than 3 minutes. But in one of our, in fact I say one of our, in our warm-up call for this last Friday, somebody said he'd like to say something about the use, and I thought it was a really good phrase, the use and misuse of safe harbor.
That was me.
That was you.
But someone else should. Okay, use and misuse of safe harbor. So safe, boy, can I do a description of safe harbor? So essentially, it's a promise on the part of American companies that, oh, you can trust us that we're going to treat data just the way you would want to treat it in Europe, even though we're in the United States. So we're making this promise, and we're going to be audited maybe every other year, or, you know, you make a bunch of promises.
It's a certification, essentially, right?
It's a certification that you're making to the Commerce Department, who is representing the American government, who's really representing the Europeans. And so that if you sign this thing and give a few details, you send it to the Commerce Department, they'll send a little thing to the Swiss and to the Europeans saying, like, these people are okay. And But the Europeans are very skeptical about this because they're like, I don't really believe they're caring about this. And I will tell you, as someone who's a former in the vendor world, probably divulging confidential information, but I fought getting safe harbor. Because you get so many offers for business if you will take this bunch of European data, bring it to the United States, and then give it to us here so we don't have to do that, right? And you know, and I would be getting pressure, you know, like people would be saying, I got this deal, you just need to have the safe harbor thing because we're supposed to move the data. I'm like, you're not supposed to move the data that way. And you know, you can imagine how many people would look the other way. And you know, and my company, you know, supported me at that point. And, you know, at that point there were reasons to think that that was a smart move at that point. You know, at this, you know, it could be that you build in tight controls around it and you can make sure it's not a problem. But you'd have to do that. And especially, so I'm saying, you know, a lot of vendors have safe harbor. I work for clients who in RFPs we require safe harbor. But it's a real area of potential abuse. And you know, the Europeans are talking about closing it down. And it's too bad because there are a lot of American companies that use it in a lot of very reputable ways.
Well, people like Visa and MasterCard and
Oh, yeah.
now,
Yeah.
see, they rely on it, but it's the, I mean, safe harbor doesn't allow onward progression once it's reached safe harbor. So, but the
right, you bring it to the United States for them, and you know it's going to the plaintiffs.
And
you know it's going
sanctions
to
are domestic
adversary
US
parties.
sanctions.
You know you were going to break that link.
You bring it to the U.S. to process it.
And into India to review it.
If you just processed it and handed it back, that'd be fine. That's what it's supposed to be for. But in reality, you process it and then produce it to a third party, and no one's gotten consent, and no one's gotten, you know. So yeah.
I mean, that's a perfect segue if we're going into what could be an hour-long conversation on the definition of the verb process in terms of what Europe considers. But I wanted to ask Joe a question about really quick about the platform. Do you think it also makes sense when the custodian has so much control over the data, their data, it belongs to them over in Europe, that like, you know, a tool like that should be in their hands rather than counsel so that they can make more informed decisions about what they want to release to either counsel, et cetera, down the road? Like, does it make sense for a custodian to have that functionality?
Absolutely. I mean, and again, I talk from a practical, not a legal perspective, but that's what I've certainly seen in the cases we've been involved in, or our platform has been rolled out for these sorts of scenarios.
I've seen HR people use it.
Yeah, HR, the custodian, sometimes the works council.
HR,
that's what it's
So this is
and it's not
the end users
process,
actually doing
it's
it?
process.
That criticism?
There's a question.
But doesn't that kind of like fall under self-collection, which is real, it's been a hot topic lately from past cases where, ranging from lit support e-discovery guys to staff, and it's just gone spiraling into an abyss.
I think it opens up the potential for you to be criticised by your opponents if you've got members of staff or other interested parties doing your redaction.
But it beats saying we're not giving you anything.
And
Yeah, but you don't have to do that. You can get other people in to do it.
Yeah, but let me sort of tag on that. As long as counsel is advising the client, because I've been in a lot of those situations where we had the clients do self-collections, but there's always the attorney or the subject matter expert on them. What are you giving me back? This is not what we're looking for. We're missing these pieces. I think that's key in order to make that scenario work.
Yeah, and if you can sort of...
I think self-collections is okay. It's sort of cost savings and everything, and the tool will be perfect for that. But if you don't have counsel on them, advising them throughout the process of what exactly they're looking for, that
depends on what stage you're in, because you can do the self-collection after producing and saying, we've complied, and then 2 years later, what were your methods? How do you defend your collection? If you're not certified as a forensics person or have some kind of experience in the industry, who's really going to get the,
Well, I think, like in the HR example, someone who's pretty knowledgeable about what the issues are, and they're pretty sensitive to the privacy, and they're kind of not a bad intermediary. I mean, if you're in a European country where the alternative is, like pound sand. I mean, there were places where, in Switzerland sometimes, you're sitting with the employee, and they're saying, no, you can't have that one, and that means, no, you don't get that. And then they literally going through their email, and they're telling you what you can and cannot have. Is that affected? Yeah. Is it the best you can do? Yeah.
How does a German company balance, like, the necessity of retention and or substantially long retention with the ownership of the data by the people rather than the entity?
The fact that they hold on to the things?
Yeah, like how can a German company tell the people, you must hold on to this for this long, when they say, well, it's mine, I can do whatever I want.
Well, I might flip that to my friend from Deutsche Bank, but I will point out that the privacy restrictions go as far as if you let's say you have a 90-day limit on that all emails will be deleted after 90 days. So typically in that situation, if there's a custodian, you put a legal hold and you stop the automatic deletion. You just at least make it so that nothing's getting deleted. You may not collect it, but you're making sure it doesn't get deleted to kind of keep Judge Peck happy, back here. That's considered a violation of privacy. To not allow the data to be deleted on its natural schedule is considered processing.
Yep.
So that's the most clever thing I have to say on that.
I think you have to be very careful as well, because even though we're talking of privacy and individual privacy, when you're talking about a corporation or organization, they own the data, the users are using it, and they have their private data within there. They protect their privacy, but the data belongs to the company. The other thing as well is, for instance, if you're looking at the banking industry, the regulatory requirements with regards to retaining data, they would be fully aware of how long that data has to be archived, kept, etc. Also, they would be aware of legal holds, etc. Because they would, when you send out the legal hold, they actually have to acknowledge it, so that they know that they themselves don't delete anything, it is still continuing while they're working. So you have to look at it from all those angles.
But like an email stating the opinion of a Volkswagen defect, does that email belong to the company or belong to the company?
It belongs to the company. As a matter of fact, you're almost stepping now onto intellectual property.
But
So
it's an
you
opinion,
have to,
though.
that which is a different, but opinion on what he's working on at the time with a research project. So that's all part of that. So you have to look at it from that point of view as well. But he is working for the company. That's company property. Now, if that document had his date of birth, his bank details, how much is in the account, that's a different thing.
Part of the challenge is, I think there are companies where, the litigation holds are not I don't say respected, but sometimes they forget about them, and
Yeah.
especially, I think it is important as people in the U.S. to make sure
Not
for your.
in the UK.
I was going to say, maybe individuals will forget that there's a legal hold on there, but not the organization or the
Well,
company.
I guess I'm talking about some cases where this has
Yeah,
happened, like
yeah.
with a Japanese
Yeah.
pharmaceutical company,
Okay.
or a couple pharmaceutical companies, Japanese and a German pharmaceutical company, where maybe it was, not a conscious decision to not save documents, but where they did get rid of documents
Yeah.
that were subject to hold. So I do think, as Americans, it's kind of funny, you think of how important data privacy is in the EU. For us, legal holds are so important, and courts go crazy. And, it is, we can meet together and we'll respect your data privacy, you respect our legal.
Just take acid together.
On that note.
Don't tweet that. No, I'm doing Twitter.
Redact.
Well, I think why don't we, we've been going for, I know we started a little late at 7:35 or thereabouts, so, you know, I think everyone's, you know, at least up here is gonna stay, have a drink, and we can continue the conversation. But maybe, why don't we end the formal part? If people need to leave, they can. We have plenty of wine and beer. Thanks to AltLaw, and thanks to AltLaw for sponsoring this. And then thank you guys for coming. But we'll stick around. People have questions, you know, keep talking. I mean, I think it's a fun topic. I think it is, and I really do think it's, you know, I hadn't really thought about it, but with these new regulations, I think the coming years are going to be very interesting. So, thanks for coming.